All right, everyone. Well, today we have a very fun topic. Do I have a contract and what are its terms? This is an interesting little academic exercise, but it comes with very real practical implications. This really comes down to what's termed the Battle of the Forms. As most all law school students know, this is an absolute behemoth, but it's very fun. Different jurisdictions treat it differently. And it really starts at a very root level. What constitutes acceptance? And so, we have the common law and the UCC, Article 2, and it starts with the common law where we go, okay, well, it's the mirror image rule. And the mirror image rule basically just says that the acceptance has to be a mirror image of the offer. And if there's anything different, well, you don't have a contract formed. Compare that with the UCC, and in Washington, this is RCW 62A 2-207, the Battle of Forms provision. And this one talks about how, from the rules perspective, an acceptance can still be an acceptance and form a contract, even though we have terms additional to or different from those contained in the offer. Notice the stark contrast from that of the mirror image rule, where if there's anything different or additional, you don't have a contract. So the rule operates to provide businesses the leeway to be able to transact business without going through the minute detail of each, offer acceptance. You can think of this like when you get a purchase order that comes in and it says, I want to buy 10 widgets for $5,000 or whatnot. And there's a backside that has all the terms and conditions. And then you're going to then give a, confirmatory memorandum that says, yeah, I accept your purchase order. I'll produce those widgets. We agree. But then your terms in your confirmatory memorandum are different from those or have additional terms from that in the purchase order. This allows business owners to not parse through the language to try to figure out, okay, what is in, what is out. The UCC provides the guideline. And so from the rule, we'll start with the rule and then we'll get into some of the academic application of it, where it's fun to see, okay, what jurisdiction is going to decide what and why. But then I'm going to finish with some practical considerations. So with that, we'll get into the rule. Like I said, it's a definite and seasonable expression of acceptance or written confirmation will operate as an acceptance even though it states terms additional to or different from those offered or agreed upon, unless acceptance is expressly made conditional on assent to the additional or different terms. Each of these are of prime import. Language matters, words matter. And so we're going to go through a series of examples, some where acceptance is not made expressly conditional, others where it is. And that expressly conditional language is really magic words. Sometimes, words aren't magic. In this case, they are. When you want the effect of something to be expressly conditional, use that language. And so with this, we'll get into our first example. And the question is a contract formed here? So here, buyer sends a form ordering 5,000 widgets for $5 each. Price buyer obtained from seller's website. This is a circumstance we see all the time. Seller then sends a memo agreeing to sell the 5,000 widgets at $5 each. But seller's form also contains a clause that any disputes are to be arbitrated in New York. It's an arbitration provision. This is an additional term in the seller's memo that wasn't included in the buyer's purchase order. Now, the parties are going to perform this contract without resolving, probably have no idea. They didn't look through the backside of the purchase order and the memo to see, okay, do we agree, do we not? And the question is, do we have a contract? And so, under the common law, you won't be surprised that at this point, we don't have a contract because there's an additional term. We don't have a mirror image of the offer and the acceptance. But thankfully, in this case, we're dealing with Article 2. And here, the seller's form is and it is an acceptance despite the additional terms. So great, we still do have a contract. The question is merely, does that additional term come in or not? And here we turn to subsection 2 of Article 2, 207, which says that additional terms are construed as proposals for addition. And this is where you always want to start because if we're not between merchants, as we're about to get into, it's merely a proposal for addition. So if we don't agree to that addition, well, then that's not part of our contract. However, between merchants, the terms do become part of the contract unless three different possibilities happen. Either the offer expressly limits acceptance to the terms of its offer, it's expressly made conditional. Two, or B, they materially alter it, or C, notification of objection has already been given or is given after a reasonable time. Basically, it's just saying, hey, I saw this proposed addition that you put forward. I don't want any part of that, so it's not going to get in. And like I said, no, it's not going to get in. And here it's because the arbitration clause is a material alteration under 2 sub B. Even if both parties are merchants, which, in this case, let's assume that they are. Like I said before, if they're not merchants, then it's just a proposal for addition. It's not getting in unless they agree to it. But if they're merchants, it still isn't getting in because it's a material alteration. Moving to example 2, I'd like to take a brief second to thank Professor Curtis Bridgman for supplying some of these fun examples. They just merely provide some guidelines so we can see, 2207 in practice. But these things happen all sorts of times. It's just people exchanging forms without noticing anything. I would also like to say briefly, Battle of the Forms is a bit of a misnomer. You can have a quote unquote Battle of the Forms with only one form. You can think like when somebody calls and says, "Hey, can I get, you know, 10 widgets for 5,000 bucks?" And then the other party, the seller, sends a memorandum along with its terms. Well, all the parties agreed to was the 10 widgets for 5,000 bucks. They didn't agree to all those additional terms, but we're still in 2207 land. Now, moving on to this example, buyer sends a form ordering 5,000 widgets for $5 each. Seller then sends a confirming memorandum agreeing to sell 5,000 widgets at $5 each. But seller's form includes an arbitration clause, shocker. This time, seller's form states that its acceptance is made expressly conditional to all its own terms, including that arbitration clause. So here we're going to look at 2207 sub 1. We have an example where acceptance is made expressly conditional on assent to its terms. So is there a contract? Again, yes, there is a contract because the parties are going to perform, but we're going to get into that here in a second. And then does it include the indemnity provision? With that in mind, here, again, 2207 sub 1, unless acceptance is expressly made conditional on assent to its terms. This is different now. Instead of us having a contract right at this point, this is now treated as a rejection and a counteroffer. So we don't have an offer right now. Instead, it's a rejection of the buyer's offer and a counteroffer. But since the parties performed anyways, there's still a contract under 2207 sub 3. While the parties failed to agree to the forms, they have a contract anyway through performance. And its terms are those that they agree upon, the price and quantity of the widgets, plus the UCC gap fillers. Here, UCC doesn't require arbitration, so the clause is left out. Looking at 2207.3 itself, it says exactly that. When we have a rejection and a counteroffer under 2207.1, it's made expressly, the acceptance is made expressly conditional on assent to its terms. Now we jump to 2207 sub 3, where the conduct is what establishes the contract. The question is just, what are the terms? Well, it's what we agree upon plus the supplementary terms of UCC Article 2. Now, the next example, this is where it gets pretty fun, is when you have different terms. So the example here is buyer sends a form ordering 5,000 widgets, $5 each. Buyer's form states that seller will indemnify buyer, and then when seller sends the confirmatory memorandum agreeing to sell the widgets at that price, seller's form states that buyer will indemnify the seller. So here we have different terms. On one hand, there's an agreement that seller will indemnify the buyer. On the other, there's an agreement that buyer will indemnify the seller. So do we have a contract? Here, the acceptance was not made expressly conditional on assent to its terms. So we do have a contract under 2207 sub 1, but what term gets in? Is seller indemnifying the buyer or is buyer indemnifying the seller? And there's really four different approaches to this, amongst others. The first shot rule, where courts in certain jurisdictions say that the acceptance is an acceptance of the offeror's terms, so those are the terms. The last shot rule, where the terms of the last form win, as if the second form were a rejection and counteroffer that is then accepted by performance. The knockout rule, which a lot of jurisdictions apply, where the terms knock out each other. So we just use gap fillers of the UCC. Basically, we say, okay, well, there's a term here and a term here, and they're different. They can't both apply, so they're both out. And we're just going to use the gap filler of 2207 sub 3. Other jurisdictions say, hey, while this is a different term, we're still going to use 2207 sub 2, even though sub 2 only specifically references additional terms. There's a comment in the UCC, this is comment 3 to 2207, which says that whether or not additional or different terms will be part of the agreement depends on the provisions of subsection 2. So some courts say, all right, we're going to relook at 2207 sub 2 and go through those three possibilities between merchants, or we're just going to treat it as a proposal for addition or difference in this situation, which doesn't really make sense. But this is where you have the intellectual titans battling it out. White and Summers are really big on this. They have a bunch of treatises on this very issue, and they disagree with each other. So this is where I say that it's an academic exercise. So moving to the practical application, and this is really the root of all of this. It's basically, well, why do I care? Which terms get in? Certainly, you want your terms in because you want to protect yourself. And so, on a baseline level, whenever you're exchanging purchase orders or sending a confirmatory memorandum, you basically always want to make your offer or acceptance expressly conditional on the other party's assent to your terms. That magic language, expressly conditional. You basically always want to have that in there because it gives you the best chance for your terms to get in. There's one situation where that doesn't necessarily help you, and that's just where your offer is made expressly conditional on assent to its terms, and then the acceptance is not expressly conditional, but instead poses additions or differences from your offer. That's really the only situation, and it's very rare, I will say that. Uh, and all that said, in light of all of this academic back and forth that's going on, at the end of the day, you just ask yourself, in the interest of certainty, is this transaction large enough to warrant me to negotiate a physical contract? Because this whole battle of the forms issue can just be solved if we sit down and negotiate a mutually executed, integrated physical contract. Now we can look at this piece of paper to say what the terms of our agreement are. If you're doing a, multi-million-dollar deal for the sale of goods, well, it makes a lot of sense to avoid this situation, make sure everybody knows what the terms are, so that then the parties can perform accordingly. But if you're dealing with, a $500 deal that you don't have the time to, parse through all the language and see, is this an additional term? Is it different from, was the acceptance expressly conditional? Which one controls? I don't want to talk to my lawyer about this. Well, you can just go forward. You may not be entirely protected or know the answer, but if you want to avoid all that, just negotiate a contract. That's going to be your best case scenario. So with that, uh, thank you. I know this is fun for some and not for others. I thoroughly enjoy all of the UCC Article 2, Article 9 related questions. If you have anything, feel free to reach out to me. I'm happy to help. Thank you.